So the purpose of the talk is to examine the theory of maṣlaḥa in the Shafi school in the classical period, focusing specifically on the 10th and 11th centuries. The other purpose is to counter the view that the Shafis are more deferential to text than to considerations of human benefit, and to suggest that at the heart of juristic grappling with the law was a vision where the identification and application of benefit, of maṣlaḥa, is subject to continual debate or continual contestation. How is this relevant to our discussion on maqāṣid? The classical model of maṣlaḥa that I focus on today, with the Shafis, differs from the maqāṣid in two regards. One, it's a model that I would contend was part and parcel of the production of substantive law, of Shafi substantive law, and therefore has deeper roots in the Islamic tradition than the maqāṣid theory. So for reformers who are concerned with questions of legitimacy within the tradition, I think it offers a little bit, it offers a better pedigree, let's say. But more importantly, the value of the classical model is the value that the classical model gives to contestation and critique undercuts authoritarian claims to knowing the purpose of the law. And I think this is very important because, as we've seen throughout these 4 days, there's a lot of ambiguity around what the maqāṣid is. Yesterday, we had a talk examining Bin Bay's use of the maqāṣid for authoritarian purposes. When I use the term authoritarian here, I don't mean political authoritarianism, but just the claims of an individual saying, well, this is what the maqsad is. And there's no discussion about it. So what's the method? The method is to examine the role of maṣlaḥa in two texts of legal theory. The first text is the Shirazi's, Abu Ishaq al-Shirazi's Sharh al-Lum'a, and the second is al-Juwayni's Burhan fi uṣūl al-fiqh. The second part of the method is to examine Shafi's substantive legal debates by examining the case of optional prayers and travel. And though I haven't listed this here, the third part of the method is to examine how contestation was a pervasive feature of the juristic landscape during this period, not just for the Shafis. Though I focus on the Shafi position, I examine how they debated other jurists. And the example that I'm going to look at is the case of the marriage guardian. So what's the maṣlaḥa position in the Ash'ari Shafi uṣūl al-fiqh? So I'm taking Juwayni as representative of this stream of Shafi uṣūl. And Juwayni says in his section on qiyas and on identification of the illah, the legal cause for a ruling, that the muhaqqiqun of the past, which I take to be a reference to his Ash'ari school, and in particular Abu Ishaq al-Isfaraini, who is an important Shafi Ash'ari, who had trained with the same uṣūl teacher as al-Baqalani and Ibn Furak in Iraq, but then had settled in Khurasan, and who al-Shirazi, Abu Ishaq al-Shirazi, says the people of Khurasan took their uṣūl from him, uṣūl al-fiqh from him. He states that the precondition for an illah is its suitability. And what he means by suitability, and this we should likely already know from the works of the likes of Felicitas Opwis, is there a benefit? Is there a maṣlaḥa? Another term sometimes used is ikhala, suggestivity of the ruling, or of the illah, pardon me. So, and Al-Juwayni also says that there is no limits to the amounts of benefits that people can identify through the text. And he says if you can't find a suitable candidate for an illah, then no analogy is permissible. It's the type of case where you can have a ruling based on the text, but you can't use that base text, that asl, to do an analogy on a different case. This method, he says, is supported by the ijma' of the companions, the early generations of Muslims. But Juwayni also adds another really important element to finding the illah, which is that it has to be subject to critique. In particular, it has to be subject to objections and to potential invalidations. So awarid and mubtilat. Another term oftentimes used by the jurists, probably more than awarid, would be i'tiradat. So critique took place in the context of disputations, munadarat, where an illah, among other things, would be tested. It would be subject to objections. Just to give an example, and the jurists, through their texts of uṣūl al-fiqh and through their texts of jadal, give a lot of potential objections to an illah. But to give one example, there's the naqd argument, where a jurist hears the potential illah of an opponent and says, okay, listen, in this other case, we see that the illah is present, but the ruling is not there. The law is not there. And therefore, you have some sort of inconsistency, and therefore you have to abandon your illah. So not any suitable or beneficial illah is the right illah. It has to be subject to critique. Now, when we turn to the Iraqi Shafi branch of uṣūl al-fiqh, we see that Shirazi does not give much attention to maṣlaḥa. Instead, he gives attention to scriptural sources for identifying the illah. So, for instance, if a text says this is the law and it adds the preposition li for such and such reason, then Shirazi says, well, that's how you know that that's the illah. Sometimes the word li is not there, but there is, through the construction of the sentence, sufficient context for the jurist to feel comfortable that there is a justification. So, for instance, Shirazi says that when the Arabs use an attribute, an adjective, when talking about a ruling applying to someone or something, the adjective is usually the illah, because he says the Arabs wouldn't have other reasons to add this adjective if it's not to indicate that it is the legal cause. Nonetheless, Shirazi does say that there are a lot of ilal which the jurists can immediately recognize as having a purpose. He gives the example of intoxication, which he says it's obvious that this is to prevent bad behavior. The prohibition of intoxication is to prevent bad behavior. It's to ensure the protection of salah. It's to ensure the protection of people's wealth and the protection of people's lives. So to conclude, Shirazi is not opposed to benefit being the basis of the law, but he wants to leave room for cases where an illah is dependent on textuality alone. Before moving on to substantive law, what's the similarity and difference between this classical model and the Maqāṣid model? So both the classical Shafi uṣūl al-fiqh model and the Maqāṣid model, the contemporary Maqāṣid model, by the way, I'm not talking about what al-Ghazali is writing, gives central importance to identifying human benefits. If we go back to Muhammad Hashim Kamali's talk, it somewhat confirms what he was saying, which is that importance to benefit is in the uṣūl al-fiqh, but it's somewhat indirect. Although with Juwayni, it's foregrounded a lot more than with Shirazi. The big distinction between the two models, in my opinion, at least so far, And I take it that I didn't flesh out any contemporary model. So that might be a criticism of what I'm saying. But the big distinction is the importance that Juwayni gives to critique. And these same types of critiques of the Illah are found in Shirazi's work as well. So let's take an example from Shafi's substantive law and see if the question of benefit or maṣlaḥa is there. And I should say before examining the example that the jurists are not using, the Shafi jurists are not using the term maṣlaḥa. Rather, they use terms that, like mashaqqa or other terms, but that gesture towards thinking about human benefit. So the 10th and 11th century Shafis affirmed that one can abandon the qibla, the prayer direction, in optional prayers while traveling. The Shafis begin their engagement by referencing textuality. So there's one hadith that says Ibn Omar used to do this, as saying, "I saw the Prophet do it," meaning abandon the qibla during his optional prayers. But the Shafis still give a reason for why this is the case. They say that there is a need between balancing there's a balancing act between people's need for travel and the continuation of people's piety through performing their optional prayers. What we see is that the application of the law follows a lot less the textual evidence and a lot more Shafi considerations about hardship. So if a person is on a boat or on a very large mount, then there's no hardship in turning to the qibla while traveling. So there's no dispensation there. If on a small mount, however, and in motion, then it would be difficult. It would stop people's travel if they had to face the qibla. And therefore, in that circumstance, they don't need to face the qibla. Same thing if on a small mount while standing still, but in a caravan where the caravan might want to resume travel soon enough, then there's no need to face the qibla. In a case where a worshiper has an obstinate mount, same thing, no need to face the qibla. But if a worshiper is alone, standing still, and with a mount that'll comply with turning, then the worshiper should face the qibla because there's no difficulty there. If walking, then a traveler can abandon the qibla, except when starting prayer, the takbirat al-ihram, except for ruku and sujood. Again, the Shafis say because there's no difficulty in such a situation. Difficulty meaning to turn in those three instances. Now, the Shafis also disagree with Malik based on this notion of hardship, because Malik said it's only valid to abandon the qibla for the optional prayers during long travels. The Shafis say, no, short travels fulfill this purpose as well. And among the Shafis, you even find one figure, Abu Sayyid al-Istakhri, who was a contemporary of Ibn Surayj's in the late 9th, early 10th century, an arrival of his in Baghdad. We find al-Istakhri saying that you can abandon the qibla not only while traveling, but at any time, because the purpose of ensuring that people can go about their business, but also fulfill their acts of worship is fulfilled. Most Shafis disagreed, citing textuality, but also saying it's not really that hard when you're in your home environment, in your home city, to just face the qibla. Now, this example here that I gave about the qibla is an uncontroversial example. But in the next example, I want to focus on, we have a case that is controversial in contemporary times. And it's the case of the marriage guardian. And marriage guardianship is controversial because it undercuts women's autonomy in various ways. in making marriage choices. What I want to do by examining the case of the marriage guardian is to show that contestation about the benefit of the law is rife throughout the classical period. We're not just contesting questions of textuality, but we're questioning the application of the law or the understanding of those texts, specifically by bringing in considerations of benefit. So I'm going to take a look at what al-Mawardi says in al-Hawi al-Kabir, the different positions that he lists and his different arguments. I'll supplement it with other texts, but I'm focusing on Mawardi here in order to give us a sense of the debates around the marriage guardian. So what are the different positions about the marriage guardian? The Shafi position is that it's an obligation, and there are texts to support the Shafi position, such as there is no marriage without a wali. But the Shafis also give justifications based off of the family's right to honor. So the Shafis worry that if a woman marries a person who is below her in terms of social status, that the family will be subject to dishonor and shame. And so a family has a right to step in and to say, no, this marriage cannot go through. And one of the ways that a family can do that is by ensuring that a woman can only be married by her wali. The Shafis also say that a family has a right to protect their women from a difficult marriage. So sometimes an unsuitable match is not based off of questions of honor or dishonor, but rather are based off of the difficulty that a woman would face in marriage. But the Shafis also debate other aspects that justify the wali. Shirazi, for instance, says that women are of deficient intellect, and therefore, because marriage is a really important issue, they can't be trusted to make decisions in marriage. Juwayni, in contrast, does not promote the idea that women's intellect are deficient and leaves things at the rights of her family. So already between Juwayni and Shirazi, we see that there's a bit of contestation happening. The Hanafi position is that an adult woman can represent herself in marriage because, well, since she is an adult and has reached intellectual maturity, and we can see this by the fact that the jurists allow her to dispose of her wealth, then she's also allowed to represent herself in marriage, be her own wali. But they still, at least some Shafis, still recommend that she have a guardian to avoid social insults about her being rebellious or impudent. Mawardi states that the Maliki position is that a woman of lowly status can represent herself because her family's honor is not at stake. Mawardi answers by saying that there's always somebody that can be lower than someone else, and therefore a family still should represent a woman. The Dhahiri position is that a non-virgin woman can represent herself because she has sufficient experience with men to choose well. So under this view, there's a type of assumption that a virgin woman doesn't have a lot of experience with marital life. A non-virgin woman will, and therefore she can choose more appropriately. Mawardi answers by saying that both virgins and non-virgins are not to be trusted with their sexuality, and says that, in fact, perhaps even a non-virgin woman should be given less trust because she would give more importance to her desires in choosing a marriage choice, a marriage partner, than somebody who has not experienced sexuality. So what resources do these classical debates give to reformers today? It's pretty obvious that if contemporary Muslims start to grapple with not textuality, but with the underlying reasons that classical jurists gave for their positions, that the law can very easily be extended. Actually, you could be very faithful to the Shafi position or to other jurist position on marriage guardianship, for instance. You could be very faithful, but show that it's applied in very different ways today. So, for instance, if Muslims today feel that the arguments around women's deficient intellect doesn't work, or that the arguments around women being misled by their sexual appetites don't work, or that virgins don't have enough experience to make wise choices, then in fact they can very easily say that the position of the wali as an obligation makes very little sense. Likewise, if family honor makes little sense to some Muslim cultures, then again, the need for a wali is undercut for those specific societies. I should mention that there is precedent in the Shafi school for this. The Shafis of Khorasan, in particular, al-Qafal al-Saghir or al-Marwazi, who's oftentimes credited for being the sheikh of the Shafi branch of Khorasan, had the opinion that honor was something that honor in lineage was only something that Arabs cared about, and therefore Persians and other peoples shouldn't give any importance to it in choosing an appropriate marriage partner. Something similar could be applied today. But there is another issue, another problem, and I'll try to wrap up. I only have about a minute needed. There's a problem of power here, because if we ask Muslims today, particularly Muslim women, to engage with jurists of the past, are we accepting that it's tolerable that they use the type of demeaning language, like that women are of deficient intellectual capacities, or that women aren't to be trusted with their sexuality? What sense of injury do we impose upon Muslim women by countenancing that juristic tradition? But even if we were to put aside the arguments of the jurists and to say, it was too marred by questions, by misogynistic assumptions, I do think that the classical model that I've identified with the Shafis, but also more broadly, the model of contestation that I've examined when looking at the question of guardianship, might offer something for Muslims today. In particular, there are two conclusions that can be drawn from this model. One, no human has full insight into the purpose of God's law. And two, no position has any worth until others are allowed to critique it. So what conclusions would I like to draw from this? First, Shafi legal theory gives central place to maṣlaḥa and its legal interpretations. Second, Shafis derive substantive laws based on the fulfillment of this benefit. Third, Shafis were part of a classical model that focused on contestation over the benefit of the law. And what's the relevance of this to Maqāṣid theorizations? Well, number one, we have a lot of overlap between the Maqāṣid model and the classical model. Both leave open the possibility that there are a multiplicity of benefits that humans must seek out as they engage with textuality. But second, the classical model foregrounds contestation and critical engagement in a way that, from what I know, the Maqāṣid models of the present do not. The classical model also, and this is perhaps paradoxical because the classical model is very hierarchical between lay Muslims and jurists. Nonetheless, I think if you were to extend it today, the classical model makes room for lay Muslims to add their voices to debates about human benefits. And what I have in mind here is the fact that lay Muslims will have more insight. For instance, lay Muslim women will have more insights into the types of arguments about the marriage guardian and its benefits than a lot of jurists would.